So, what we learned in 1913 is that the United States, not to confuse the United States of America, two separate entities. They transferred all the assets of the colonists. These people were chiefly British. They're not white people. They're not even the sovereign Americans, which America is a political term. Because we're the Aboriginal indigenous people. We're the Moors, Moabite Canaanites. So America is a contemporary term. It's a political term. So therefore, what you must understand is the colonists, who were chiefly British, transferred the assets of the Moors over into a trust called the Federal Reserve. And the Federal Reserve is a corporation. It's an international bank, but it's a corporation. It's not under any type of government whatsoever. It is a standalone corporation all by itself. It's international. It does not come under the auspices of the United States of America or the United States. It is a standalone corporation. That must be known. And they own all the assets of the United States of America and the United States jurisdictions. That must be understood. All right? So what else did we learn? Why did they crash it in 1913? Well, Noble Drew Ali is coming on the scene in 1913. He's putting in work. He's putting pressure on the colonists because he's making claims under consanguinity. He's making claims as a Moor. He's making claims to the treaties, right? And then here comes France. France is working from the outside in. Noble Drew Ali is working from the inside out, and they're flanking. They're flanking the United States of America, not to be confused with the United States, two separate entities, right? They're putting pressure. So the United States of America, they panic. So Woodrow Wilson goes to Jekyll Island, right? Remember that? He sets up the bill that now they take over to Washington, D.C. Washington, D.C. D.C. standing for District of Columbia, the corporation. They pass a bill called the Federal Reserve Act. And lo and behold, what do? They transfer the assets of the Moors into a different trust.
Can I ask how much it was?
I don't know, Mother. Okay. Yeah, that's a good question. It's hard to count it. Yeah. Okay, back to point. So, what we must understand is this. Why is the United States so erratic? Why are they doing things so radical? We must understand that the Moors are always trying to get their estate back. At the same time, France has always been a thorn in the side of the United States of America. Why? It's because France has never forgot about the fact that they helped the colonists to defeat the British in order for them to get their sovereignty in the land. France has never forgot about that. So you must understand that France signed a treaty with the United States of America in 1778. Then the United States of America in 1798, under the Enemy Alien Act of 1798, decided to cut ties with France. This is well after the fact, after they had defeated the British. All right? So what you must understand is France has always been trying to help the Moors to get their sovereignty back. All right? So today, what we're going to learn is a little bit more about history. We must always study law and history. The mothers must understand law and history. Why? We must point out the problems. And once we point out the problems, then we point out the solutions. There's no use in talking about problems unless we talk about solutions, right? All right. So therefore, the mothers have to fix it with a pen. And how do the mothers fix it with a pen? We must start understanding legislation. That's exactly what we're studying right now. We're studying law. The mothers must study law. That way, when they put together a matriarchal council, they can enforce said law. Because first you got to figure out what went wrong and what you have to do to make sure we don't repeat that history again. All right? So they'll continue to study international law. So today we're going to talk about extraterritorial jurisdiction. I talk about that quite often. Extraterritorial jurisdiction, which is really what you call compulsory jurisdiction. Compulsory jurisdiction. But we'll talk about extraterritorial jurisdiction, and we'll also go over quite a few documents today, so prepare yourself to do a lot of research. All right? So first thing we're going to do in the Black's Law Dictionary, 4th edition, is go to the definition of extraterritoriality. All right? So we can have one of the mothers read the definition of extraterritoriality. That would be great.
The extraterritorial operation of laws, that is, their operation upon persons, rights, or jural relations existing between the limits of the enacting state, but still amenable to its laws. A term used especially formally to express in lieu of the word extraterritoriality. Extraterritoriality, quote unquote Q.V. The exemption from the obligation of the laws of a state granted to foreign diplomatic agents, warships, etc. The term is used to indicate jurisdiction exercised by a nation in other countries by treaty, as by the United States in China or Egypt, or by its own ministers or consuls in foreign lands. Crime is said to be extraterritorial when committed in a country other than that of the forum in which the party is tried.
All right, thank you, Mother. So let's go back and do our interpretation of what did we just read. Moors must always understand we must learn how to read. What does that mean? We must use forensics. We have to go back and try to get an understanding, an overstanding, and an understanding at all times. And every time we read, it means to comprehend. Forensics. So let's go back and use forensics, okay? Let's examine. Let's use more science, okay? So first things first. Keep in mind, why are we reading the definition of this word? You must understand what the United States of America, not to be confused, the United States is doing to the Moors, okay? But we're going to talk about this a lot more in detail today. So watch this. Extraterritoriality, the extraterritorial operations of laws. That is, their operation upon persons, not people, persons, rights, or jural relations. What is jural relations? Judges, right? Legislation. Existing beyond the limits of the enacting state. So what's happening? The United States of America, not to be confused, United States is extending their jurisdiction of laws way past their limits of what the United States of America is supposed to do as it relates to Moors. Okay? That must be understood. They're extending their jurisdiction over into our jurisdiction. You're talking about two separate nations. Keep that in mind. We must always be cognizant of what we're talking about right now. Okay? Two separate nations. United States of America and the Moors nation. Okay? So United States of America is overextending as an overlay on top of the Moors. They're not supposed to do that. It's supposed to be two separate nations. But they're extending themselves, which means they're usurping our rights as Moors in our own homeland. Okay? Now watch this. So they're explaining now. Keep in mind, the colonists wrote the book. But they're using our law to enslave us. Always remember this. This is not the so-called colonist law. This is our law that we have forgotten through psychosis and cognitive dissonance. And now they're using our own law to enslave us. Always remember that, okay? Let's continue. It's amenable to law. A term used, especially formally, to express in lieu of the word extraterritoriality, the exemption from the obligation of the laws of a state granted to foreign diplomat agents, warships, etc. So what's happening here? So there's exemptions as well for certain diplomats who come over. They don't have to worry about extraterritoriality, okay? They're exempt. They have what's called diplomatic immunity. They don't have to worry about being usurped. They're still under the auspices of the laws. So therefore, if someone from China comes over to Morocco, they still come with their law with them. They don't have to worry about the local laws of Morocco. They still get to maintain the laws of China. So therefore, those laws travel with them abroad. Okay? Let's continue. The term is used to indicate jurisdiction exercised by a nation in other countries. What's happening? So the United States of America is exercising extraterritorial jurisdiction over Morocco. It's extended. Okay? That's a violation of law as it relates to international law. Let's continue. How are they doing it? By treaty, as by the United States in China or Egypt, they give you examples, or by its own ministers or consuls in foreign lands. Crime, I say again, crime, I say again, crime is said to be extraterritorial when committed in a country other than that of the forum on which the party is tried. So what's happening? United States nationals who have a state, the United States of America tries to use that extraterritorial jurisdiction to overlap as an overlay. Now they're committing a crime. They can't do it. So what's been happening? Moors have been in courts. Moors have been filling out documentation. The United States of America has been saying the Moors don't have a state. So the United States of America is saying, we're not overlapping nothing. There's no extension. We're not overextending our jurisdiction because guess what? Moors don't have a state to have any type of extraterritorial jurisdiction over. Now, don't get me wrong, AMPAC has a state. We're poised to have full powers because we've checked the boxes. It's happening. The United States of America is saying the Moors don't have a state. So there is no extraterritorial jurisdiction. They're not usurping Moors' state rights because Moors don't have a state. But once the Moors have a state, keep in mind, AMPAC has a state, but the other Moors create their states. Now the United States of America, they try to overlap, to abridge, to usurp through use of force our state governments. That is what? A crime. That's a crime. I'm going to go deeper, so just pay attention. Okay. Now, I want to go over a document that a lot of Moors have been using, but they have misconceptions because they haven't been using what's called fundamental understandings of international law. Judge Bey always says we must have a nation state, a nation state, a nation state. But what is he saying? You must understand international law. Moors have been reading documents but not studying international law in order for them now to have a cross-reference exactly how to enforce their rights. Watch this. Let's go to what's called Title 22, United States Code, subsection 141 through 143. What is that? That is a United States Code that Moors love to put on their documents. And guess what? Our concepts have been flawed. I'll talk about it today. All right. So we can have one of the mothers read Title 22, which is on the document says Title 22, Chapter 2, sections 141 through 143. All right? Yeah. And it talks about the heading is what, mother? So Title 22, one of the mothers can read.
Foreign Relations and Intercourse, page 954, Chapter 2, Consular Courts, Section 141, Judicial Authority generally, to carry into full effect the provisions of the treaties of the United States with certain foreign countries, the ministers and consuls of the United States in China, Siam, and Turkey, Morocco, Muscat, Abyssinia, Persia, and the territories formerly a part of the former Ottoman Empire, including Egypt, duly appointed to reside therein, shall, in addition to other powers and duties imposed upon them, respectively by the provisions of such treaties, respectively be invested with judicial authority described in this chapter, which shall appertain to the office of minister and counsel, and be a part of the duties belonging thereto, wherein and so far as the same is allowed by treaty and in accordance with the usages of the countries in their intercourse with the Franks or other foreign Christian nations.
Stop. Okay, thank you, mother. Let's go back and use our interpretation. This is a really bland read, right? It's not really fancy, but watch this. Title 22, Foreign Relations and Intercourse. What's happening? United States of America, not to be confused, the United States is now setting aside legislation, their domestic legislation, as it relates to foreign relations. Foreign relations with who? Moors. That must be understood with the Moors, because they know they have usurped the Moors, okay, under extraterritorial jurisdiction. All right, now watch this. Section 141 talks about what? Judicial authority. What's that? Judges. Legislation is created, and then judges carry out that law. They interpret the law, they enforce the law. So you're talking about judges. Remember what I said? The judges are the gatekeepers to the jurisdiction. They protect the legislators. So you got judges on the front line protecting the legislators back here. Legislators write the so-called law, and the judges and the police enforce it, and they protect the legislators. Okay? So judges and police are what you call your front line of defense. They are the gatekeepers. Okay? So that's why it says judicial. That's your senators working together with their appointed judges, alleged judges. All right? To do what? To carry out into full effect the provisions of the treaties of the United States with certain foreign countries. Who's the foreign country? Morocco. Must always keep that in mind. They talk in code. The ministers and consuls of the United States in China, Syria, Turkey, Morocco, Muscat, Abyssinia, Persia, and the territories formerly as a part of the former Ottoman Empire, including Egypt. So as soon as they say Ottoman and they say Morocco, that's one expansive empire. It expands. So you're talking about the continent of America, you're talking about the continent of Africa, you're talking about the continent of Asia, you're talking about the continent of so-called Europe. That's the world. That's the truth. Watch this. So duly appointed to reside within shall, in addition to other powers and duties imposed upon them. So what they're talking about right now, they're telling you they're imposing some powers on them. Who's the them? Moors. Respectively, by provision of such treaties. So what are they using? Treaties to enforce some rights on top of Moors. Watch this. They're spelling it out, but you got to catch it. Respectfully, be invested with judicial authority. What authority? Judges' authority. Described in this chapter, which shall appertain to the office of minister and consul, and be a part of the duties belonging thereto within, and so far as the same is allowed by treaty. They're talking treaty. And in accordance with the usage of the countries and their intercourse with the Franks or other foreign Christian nations. So it's a very boring read. What are they saying right here? Let's keep it simple. United States of America, or on their document, saying the United States is telling you they still have some judicial powers over Morocco. Because you remember now, it's listed under what? Judicial authority. They mentioned Morocco. Watch this. Now, we're going to get into Section 142, which is called the general jurisdiction in criminal cases. So now I say judges. Now we're going to read what's under status of criminal and civil, because they've already said the judge is judicial. Now we're going to learn what type of jurisdiction they think they have over Morocco from a criminal and civil perspective. Watch this. Go ahead and read it, Moses.
General jurisdiction in criminal cases. The officers mentioned in Section 141 of this title are fully empowered to arraign and try in the manner provided for this chapter all citizens of the United States charged with offenses against the law committed in such countries respectively, and to sentence such offenders in the manner in this chapter authorized, and each of them is authorized to issue such processes as are suitable and necessary to carry this authority into execution.
Okay. Now we must use our Moorish science based upon reading. What am I saying? You got to use some forensics. They're talking Moorish code, Morse code, M-O-R-S-E, Morse code. What is that? They're secret societies, because they know Negro, blacks, and colors don't like to read, and they know Moors don't read too well either. Because Moors will skim words, think they got the understanding, and they run off and start scribing documents. Watch this. So what more science should we use? Watch this. Take it from the top. General jurisdiction of criminal cases. Remember now, they're talking about how they're going to enforce something on Moroccans. The officers mentioned in section 141. You see how it's underlined? They're trying to give you a code. Go look back up 141. Okay, so we go back and look at 141. What was they talking about in 141? Judges, judicial. Listen, they say go back and look at 141. Judges, they tell the judges, you still have authority over these Moors. Watch this. Of the title are fully empowered to arraign and try in a manner provided for this chapter. What about this chapter? This is for a criminal chapter. You got to use your Moorish science. Watch this. All citizens. You see how it's underscored 2 lines? That's Moorish science. You got to use Moorish science to see what these colonists are doing. What did they just do, Moors? This is what Moors been missing. Moorish subjects, not Moorish nationals. Moorish subjects been missing this. Moors been running around saying, we ipso jure Moorish subjects. They're happy. Guess what? You're admitting on the record you're still a citizen. Citizen what? United States. Watch. It's got a double underline. All citizens. Why are they saying that? Listen. Because if Moors don't have a state of their own, you're still a citizen or a subject of the country that's protecting you. So therefore, they're talking Moorish science right here. They're talking Morse code, saying these Moors are still citizens. They don't even realize it because they don't have a state. So Moors been filling out documents, can't wait to put Title 22, United States Code 141 and 143, and the colonists been laughing at us. They saying they don't even know how to read. We put the answers to the test right in front of their face. I don't say that as a negative or condemnation of any more that's been putting the work out here, because we've been trying to put brakes on this thing. I applaud everybody that's been trying. But guess what? We got to fix this thing. We got to start studying international law and learn how to read. Judge Bey says people either don't know how to read, and those who can read won't. He's correct. We're going to keep breaking down this Moorish science today. Watch this. So I'm going to say it for the record again. There's only 3 classifications of Moors. Listen. There's Moorish subjects, Moorish proteges. We learned about that. If you go back and watch the video of the French protectorate, they call us proteges. It's a French word, proteges. And then there's Moorish nationals. There's only 3 classifications of Moors. Moors must understand this. Moorish subjects, Moorish proteges, Moorish nationals. What makes you a Moorish subject? You don't have a state. What makes you a Moorish protege? That means you're on somebody's protection list, but you still don't have a state. You're still a stateless person. You come under protection of somebody. But if you're a Moorish national, that's because you have a state. You have a constitution, oath and allegiance, birth records, consular court, etc., etc., etc. You have a provincial flag and a seal. You are poised to have full powers as Moorish nationals. Until then, you're still a Moorish subject or a Moorish protege. Those are the 3 categories. Listen, everybody has a right to self-determination. It's called Islam. I, self, law, and master. You got a right to be a part of one of these 3. You have a right. However, if you want to enforce your rights under treaty rights, because they're talking treaties, you have to be a Moorish national with a state. That's the truth. Moors must start understanding this. We must comprehend law. Let me continue from the top. The officers mentioned in section 141, judicial judges, they're talking secret, you judges still got power, of the title are fully empowered to arraign and try in the manner provided for this chapter. What chapter? Criminal chapter. All citizens, Moors are citizens of the United States. Of the United States charged with offenses against the law. What law? Their laws, the colonist law. Committed in such countries, respectively, and to sentence such offenders. What are you offending? The colonist law, because you don't have your own state. Listen. In the manner in this chapter authorized. Why do they underscore it? They underline it, see? They're talking Morse science, Morse code, but we must use Morse science and understand what they're doing. In the manner in this chapter authorized. What's authorized in this chapter? Criminal cases. Most Moors will read right past that. Why? Because they ain't reading, they pronouncing words. That's not a negative, not a condemnation of any more. I applaud your work. But we've been operating in an incompetent manner because we have misconceptions. Misconceptions. Which means our concepts have been flawed about real law. They've been giving us the answers to the test the whole time. This document came out in 1956. It's the year 2021. Let's continue. And each of them is authorized. Who's of them? The judges. They underscored in section 141. You got to understand more science to read these things. To issue such process as are suitable and necessary to carry out this authority into execution. What's execution? Execution. Off with your head. Because they're executives of the district of the Federal Reserve. When we looked up the definition of Federal Reserve, it said its definition means district, and districts have executives who oversee it, including these pseudo judges. They're not judges, they're administrative clerks. They're not real judges. They're executioners, just like these police out here. That must be known. Moors have misconcepts to think that this 141 protects us. It only protects Moorish nationals. I'll prove it. Let's continue. Okay, so Title 22, Chapter 2, Section 143. All right, so we read 141. That's what? Judges. We read 142. Now they're talking about what do the judges do? Go ahead and usurp criminal cases, execute them. That's everything from a $50 broken tail light all the way to life in prison. That's what execution is. Execution of what? Legislation, their statutes, codes, ordinances, policies, and sometimes the death sentence. That's the truth. Okay, now let's start understanding 143. Why are we studying this? Because the Moors have been using Title 22, United States Code, subsection 141 and 143, thinking it's giving them some remedy, and it is not, because their concepts have been flawed, misconceptions. I'll prove it. Okay, Mother. Title 22.
Title 22, Chapter 2, Section 143, General Jurisdiction in Civil Cases.
Stop. So we went from criminal, now we're talking civil. Okay? So they're checking the boxes. Continue, Mother.
Such officers are also invested with all the judicial authority necessary to execute the provisions of such treaties, respectively, in regard to civil rights, whether of property or persons, and they shall entertain jurisdiction in matters of contract at the port, whereof nearest to which it was to be executed, and in all other matters at the port where, or nearest to which the damage complained of was sustained, provided such port be one of the ports at which the United States are represented by counsel, such jurisdiction shall embrace all controversies between citizens of the United States or others provided for by such treaties, respectively.
All right. So we're talking civil matters. Why do they keep talking about ports? You have to remember, we talked about Noah's Ark. They're using admiralty and maritime law, saying that the whole world is underwater, that North America is underwater, and that everything they're using now on the admiralty and maritime law is based upon vessels, ships. But remember, you're also a vessel too. You have blood vessels. So they're talking on multiple levels right now. Okay? Also, you got to catch some other choice words. You got to use your Moorish science because they're using Morse code. Watch this. So Title 22, Chapter 2, Section 143, Moors love this. General jurisdiction in civil cases, Moors say they don't have no rights, they don't have no jurisdiction over us from criminal or civil. Watch this. Such officers are also invested with all the judicial authority. Who are they talking about? Judges, barristers, cops. Let's say to execute the provisions of such treaties. They keep talking about treaties, so you must understand treaties is supreme law of the land. That's why they keep bringing it up. Respectively, in regard to civil rights. Who keeps talking about civil rights? People who think they're crayons. So now you know who they're talking about. Moors, unconscious Moors. Rather, the property of persons, not people, persons. Persons is what? Property. Of who? United States, not to confuse the United States of America. Persons is an artificial construct. It's a nom de guerre. It's listed on what you call the 14th Amendment for corporations. So therefore, persons is not people. It's a different classification under what's called a caste system. So as soon as they call you a person, they immediately are trying to declassify you, meaning they're trying to denationalize you and trying to put you under a status called chattel. Chattel, which is the compound word for Christian cattle. Chattel. That's true. Continue. And they, who's the they? Them, judicial, shall entertain jurisdiction. Shall entertain jurisdiction. Shall entertain jurisdiction. So they claim they have jurisdiction over who? They told you in the first paragraph. Morocco. Who's Morocco? Moors. Listen. In matters of contract, at the port where, or nearest to which, it was to be executed. And in all other matters, at the port where, or nearest to which the damage complained or was sustained, provided such port be one of the ports at which the United States are represented by counsel. Such jurisdiction shall embrace all controversies between citizens of the United States or others. Wait a minute. They're just telling you right here that the judges over criminal and civil matters still have jurisdiction over who? Citizens of the United States. Who's a citizen of the United States? Moorish subjects, Moorish proteges. They're still citizens of the United States. Why? Because they don't have a state to call themselves Moorish nationals. So you fall under the guidelines of the statutes, jurisdiction of the United States of America. Not confused with the United States. They tell you right there, 143, they have jurisdiction. They listed the parties. Listen, the parties must be known. Didn't they list the parties first in section 141? Then they went right in to tell you what jurisdiction they had, criminal and civil. But Moore has been using this document. You know why? Because they do have rights as Moors. Under this document, if they ain't Moorish subjects or Moorish proteges, they must be Moorish nationals with a state. But the United States of America ain't their job to tell us that. We have to protect ourselves. We must recognize ourselves. We must be competent in international law. We have been getting this wrong. How do we fix it is the question. You need a state, mothers. Only the mothers can fix this. Your son's been running roll because your sons just want to fix it. They're excited. They just want to get out of harm's way. They got pain. They just want to fix it. And as soon as they read something, they think they read it, they think they got it. Oh, I got this covered. They zip right past the most important, vital elements, critical elements of documents. The average Moor haven't caught these specifics. But Moorish nationals do. Watch this. Now we're going to get a little deeper on this same document, because Moors love this document. Watch this. Now we're going to go a little deeper with what they call the public law. Moors will pull out the public law that goes into the details of Title 22, United States Code, subsection 141 through 143. Now we're going to get some details. What does the United States of America, not to confuse United States, really say about what we just read? It's called Public Law, August 1st, 1956. This is your House of Representatives. I believe it's your Senate. This is now going to get into the details of what we just read, right? Okay, and we can have the mothers go ahead and start reading where it says, whereas
the councils of the United States and Morocco are permitted to exercise jurisdiction over American nationals under the treaty between the United States and Morocco signed September 16, 1836, and the Act of Algeciras signed April 7, 1906, and the exercise by custom and usage the same jurisdiction over subjects of Morocco or others who may be designated as proteges under the convention, designated as quote-unquote proteges under the Convention of Madrid, signed July 3rd, 1880. And whereas Morocco is now the only foreign country where the councils of the United States exercise such jurisdictions, and whereas it is the policy of the United States to discontinue the exercise of extraterritorial jurisdiction in Morocco at such times as it becomes appropriate.
Stop. So let's go back and use some more science. Most Moors will go straight to that last sentence, and that's where they hang their fez. Watch this. I'm just going to read the last sentence. It says, whereas it is the policy of the United States to continue the exercise of extraterritorial jurisdiction in Morocco at such time as it become appropriate. Everybody say, oh, United States don't have extraterritorial jurisdiction. They don't have jurisdiction over Moors. They misunderstand, misconcepts. Their concepts are flawed. Watch this. I'll take it from the top. They're giving you the answers to the test, but Moors don't read. We pronounce words. Watch this. Whereas the councils of the United States in Morocco, so they're letting you know the United States is in Morocco, are permitted to exercise jurisdiction over American nationals. Stop. They can exercise jurisdiction over American nationals. Who's the American nationals? The Moors. But the United States of America citizens also claim to be American nationals. So they're talking both so-called residents, because they're making a claim to the Moors as their chattel property as being nationals as well. Watch this. I'm going to take it from the top. Whereas the Council of the United States in Morocco are permitted to exercise jurisdiction over American nationals, and under the treaty between the United States and Morocco signed September 16, 1836, so they're talking about the Treaty of Peace and Friendship, 1836, and the Act of Algeciras signed April 7, 1906. You got to go back and do your research. We'll talk about that. And the exercise by custom and usage the same jurisdiction over subjects of Morocco. Remember, there's 3 classifications. They just told you they have what? Jurisdiction over who? Subjects of Morocco. They tell you verbatim right in front of your face. Most people ain't catching that. Or others who may be designated as what? Proteges. They have jurisdiction over Moorish subjects and proteges. Guess who they don't have jurisdiction over? Moorish nationals. Do you see how slick they threw in the word American nationals? If you're a Moorish national, i.e. a Moor, according to the treaties say you're a Moor. But they don't have jurisdiction over Moorish nationals because that would be a crime to now try to have extraterritorial jurisdiction over Moorish nationals who have a state who are following international law. The Moors use this public law. They read it proudly, misinterpret it. That's not a negative or condemnation of any more out here putting in work. I appreciate it. But now we must start understanding the fundamentals, the proper concepts of law. Watch this. I'm going to go back to where it says, and the exercise by. So it says, and the exercise by custom and usage. What does custom and usage mean? They just, under custom and usage, they used to just Moors being incompetent. Moors being NBCs. That's what they're saying. The same jurisdiction over subjects of Morocco or others who may be designated as proteges under the Convention of Madrid signed July 3rd, 1880. Notice they keep talking about treaties. And whereas Morocco is now the only foreign country where the Council of the United States exercise such jurisdiction. They're telling you they got jurisdiction over Moors. Right there they said, the United States is the only country that got some jurisdiction over these Moors. Where? Commonly known North America, the Moroccan Empire. The United States is the last country on planet Earth, so-called country, to have jurisdiction over Moors. Why? Because the Moors don't have a state. That's why. Watch this. Whereas Morocco is now the only foreign country where the councils of the United States exercise such jurisdiction. They're telling you they got jurisdiction. And where it is the policy of the United States to discontinue the exercise of extraterritorial jurisdiction in Morocco at such time as it becomes appropriate. Moors missed that part about appropriate. What are they saying? We still got jurisdiction, but when these Moors get a state, that's when we can't use extraterritorial jurisdiction no more. Why? Because then the Moors are no longer subjects, they're no longer proteges, they're just nationals. We must understand what we're reading, Moors. That's the truth. Okay, let's continue the reading. Go ahead, Mother, please.
Resolved by the Senate and House of Representatives of the United States of America and Congress assembled, that the relinquishment by the President at such times as he considered this appropriate of the consular jurisdiction of the United States in Morocco is hereby approved, and sections 1693, 4083, and 4091 inclusive, 4097 to 4122 inclusive, and 4125 to 4130 inclusive of the revived statutes as amendment are repealed effective upon the date which the President determines to be appropriate for the relinquishment of such jurisdiction, except so far as may be necessary to dispose of cases then pending to the consular courts in Morocco.
Okay. So what did we learn? Approved August 1st, 1956. Thank you, Mom. Let's go back to the top. They're giving you more secrets. Moors love using this. Totally miss concepts based upon how it should be used. Resolved by the Senate and House of Representatives of the United States of America. United States of America. United States of America. I thought they was the United States. This is 1956. They turned the United States in 1871. See how they keep bouncing back and forth between two jurisdictions, United States of America, not to confuse the United States. They use them interchangeably. Why? Because when they're talking international law, they say United States of America. When they're talking domestic, they say United States. So if they're talking United States of America, they're talking international. That's why they keep talking about treaties and dealing with Moors. You got to catch it. Watch this. That the relinquishment by the President at such time as he considers this appropriate of the consular jurisdiction of the United States in Morocco is hereby approved and sections, on the consular jurisdiction of the United States and Morocco is hereby approved, and sections, and you get all your sections. Then it continues to say, inclusive of the revised statutes as amended, are repealed effective upon the date which the President determines to be appropriate for the relinquishment of such jurisdiction, except so far as may be necessary to dispose of cases then pending in consular courts in Morocco. Now, wait a minute. They're admitting they're in Morocco. They're saying they're going to get rid of any cases once Moors figure out that they need a state. Until then, they're going to maintain sections 141, 142, and 143, which is execution, adjudication of Moors subjects, Moors proteges. Until Moors figure out they need a state. So yeah, they're saying they're playing a game. They're saying, yeah, we'll remove extraterritorial jurisdiction because we know Moors don't have a state. They're playing with words, but Moors have been laughing at us the whole time. But it ain't their fault. It's the Moors' fault for not really comprehending what they're reading. If Moors don't have a state, then that means the United States of America can't usurp your state. So they're saying, we won't do no extraterritorial jurisdiction. Wink, wink. Because these Moors ain't got a state. This is 1956. We're in the year 2021. That's not a condemnation of all the Moors who've been putting in work. But we must start now putting things in proper sequential order, understanding that first we need to put together your nationality, proclaim your nationality, and start checking the boxes. Until then, we're still stateless people. More subjects. Let me continuously prove this to you. One of the things we have to constantly understand is that France has been trying to help us with the answers to the test. Always remember that France is the common denominator to working side by side with the Moors. They have been since the year 1631. So in 1631, it's called the Franco-Morocco Treaty. France and the Sultan of Morocco came together and put together a treaty. So ever since 1631, we're in the year 2021. That's nearly 400 years of history between Moors and France. Has it been an up and down relationship? Yes, it's like a marriage. But a partnership, an alliance, an ally nonetheless. People ask the question, well, why did the United States just relinquish jurisdiction in Morocco all of a sudden? You must understand the history, Moors. It's because of what France did in 1952. Let's put it in proper sequential order. In 1952, France took the United States of America to the International Court of Justice because France was claiming what's called jurisdiction and protections over the Moroccan Empire at that time. So watch this. Moors keep saying United States don't have jurisdiction over Moors. Guess what? That's false. That's not true. They still have jurisdiction over Moors that are Moor subjects and Moorish proteges. I'm going to keep proving that today. I got reference points. Watch this. So what you do is, for people at home who want to find a reference point, you go look up France versus United States 1952, the ICJ case. Look up what's called the judgment, and you'll get that document. Okay, so we have the mothers read the title, and then we will go straight to sections 2 and 3. Watch this. Go ahead, mother.
Case concerning rights of nationals of the United States of America in Morocco. The proceedings in
what date, mother?
Judgment of 27th August 1952.
Okay, so stop. So we just read some 1956 documents, right? Mm-hmm. We go back 4 years, 1952, because now we're putting things in sequential order to understand why do they do all that? Why do the United States just jump up all of a sudden just want to just relinquish some jurisdiction? Because they got the answers to the test on how to hold on to these Moors. Watch this. Go ahead, Mother.
The proceedings in the case concerning rights of nationals of the United States of America in Morocco were instituted under the United States against the United States by an application of the government of the French Republic.
Stop. So France is bringing them into court, dealing with a dispute, one nation versus another nation, because they both got states. Because if they didn't have a state, they couldn't go to the ICJ. Let's continue.
The submissions of the parties related to the following principal points. The application to nationals of the United States of the residential decree of December 30th, 1948, by which imports without official allocation of currency, imports from the United States were in the French zone of Morocco subjected to a system of licensing control.
Stop. So first things first, France is arguing with the United States over control over territory over the Moroccan land, okay? But what's germane to this subject? We're going to go down to now Articles 2 and 3 show you exactly what the judges said in the International Court of Justice about Moors and the United States jurisdiction. Watch this. Reference point. Okay, Mother, if you can read section 2, please.
2, quote unquote, unanimously with regard to consular jurisdiction in the French zone of Morocco, the United States is entitled to exercise such jurisdiction in accordance with the terms of its treaty with Morocco of September 16, 1836. That is to say, in all disputes, civil or criminal, between citizens or protégés of the United States.
Stop. Let's read it again. This is the ICJ. 15 judges unanimously, all 15 said what? With regard to consular jurisdiction in the French zone of Morocco, what's the French zone of Morocco? That's the Moroccan Empire. The United States is entitled to exercise such jurisdiction in accordance with the terms of its treaty with Morocco of September 16, 1836. That it so say that in all disputes, civil or criminal, between citizens or protégés of the United States has jurisdiction over Moors. There are still subjects and protégés. Moors been out here filling out documents, adamant of jurisdiction, quo warranto, questioning the colonists. Colonists are saying, y'all don't read instructions. Y'all don't have a state. Y'all consider ipso jure Moorish subjects. You don't have a state. Y'all consider Moorish protégés. You don't have a state. Which means the United States of America, not to be confused, the United States gets to continue to classify you as a United States citizen. Which means their laws are applicable to these people who call themselves conscious Moors. That's not a negative. That's just a demonstration of the proof, the de jure proof, from a world court that's what you call non-biased and competent. Why? Because international law of the Vienna Convention of 1969 says what? Watch this. Article 1 says what? Scope of the present convention. The present convention applies to treaties between states. Moors don't have a state, so therefore, in the international law, you can't enforce treaties, which means you're still a subject and a protégé. You ain't a Moorish national. You're a stateless people with a nationality. Okay, Mother, go ahead and read section 3 for me, please.
3. By 10 votes to 1, it is also entitled to exercise consular jurisdiction in all cases, civil or criminal, brought against citizens or protégés of the United States, to the extent required by the provisions of the Act of Algeciras relating to consular jurisdiction.
Okay, so let's go back and do our interpretations. They're in a strict sense. Watch this. Moors say, United States don't have jurisdiction over Moors. That's not true. The question is what type of Moor? Are you a Moorish subject? Are you a Moorish protege? Or are you a Moorish national? Because you got a right to pick one of them. Watch this. So what does the ICJ say? International law, number 3, section 2 of their judgment, by 10 votes to 1. It is also entitled to exercise consular jurisdiction in all cases, civil or criminal, brought against citizens or protégés of the United States. To the extent required by the provisions of the Act of Algeciras related to consular jurisdiction. So which Moors is the question? Which type of Moor are you? There's only 3 classifications of Moors. Listen. Reference point. The ICJ says you're still a United States citizen. Moors must comprehend you only got 3 classifications, Moors. Subject, protege, national. That's it. Pick one. You want to be a national? You must create a state. Check the boxes. Moorish subjects been sending all kind of documents to the colonists. The colonists is laughing at us. Saying they ain't figured it out yet because they don't read, which means to comprehend and use forensics. But Moors keep using this document. Man, the ICJ said the United States don't have jurisdiction over us. That's not true. Matter of fact, they said just the opposite. It was unanimous. But how do we fix it? Ain't no use in pointing out problems unless you got a solution. Mothers, you got to bring your rogue Moors back into the matriarchal council and create legislation to save your fallen humanity of Moors. That's the truth. Mothers, you have to create a state. You have to use that intellect that you have to create a state. Bring your Moors in, create the state. Check the boxes. Now you're poised to have full powers to be a Moorish national and no longer subjects and protégés. That's the answer to the test. Watch this. I'll keep proving it. Watch this. They keep talking about 1836, right? Peace and friendship. 1836. Right? Mother, can you read Article 1 for me? Because all the Moors say, go to Article 20, go to Article 22, go to Article 23, go to Article 24. They skip right past Article 1. Let's read Article 1.
Article 1. We declare that both parties have agreed that this treaty, consisting of 25 articles, shall be inserted in this book and delivered to James R. Lee, agent of the United States, and now their resident counsel at Tangier, with whose approbation it has been made and who is duly authorized on their part, and to treat with us concerning all the matters contained therein.
Okay, we're going to stop at Article 1. We're not going to look up any more articles because Moors ain't been able to check the box on Article 1. What happened? Watch this. We declare that both parties, in order to be a party, you must have a state. That's the truth. Both parties have agreed that this treaty, consisting of 25 articles, so therefore the 25 articles only relate to people who got a state, shall be inserted in this book and delivered to James R. Lee, agent of the United States. Who's an agent? Someone has been appointed by someone that's duly elected, that has checked all these boxes. So the United States of America, not to confuse the United States, saying we check the boxes that authorize them to go negotiate a treaty. Watch this. And now their resident consul at Tangier, with whose approbation it has been made and who is duly authorized. Moors aren't duly authorized to do nothing. They can't enforce treaties unless they have a state become elected officials, not self-appointed. You must be duly authorized. What duly mean? Elections. Moors must start understanding international law. Watch this. Start with whose approbation it has been made and who is duly authorized on their part to treat with us concerning all the matters contained therein. You must be duly authorized in order to do anything in regards to the matters of the entire treaty. Ain't no use in talking about Article 2. Two more to get past Article 1. Our misconceptions. We have missed the concept of understanding state. I'll give you more reference points. All right. They keep talking about the 1906 Act of Algeciras, which is a multilateral treaty with Morocco. If you go to Article 101, so Moors at home, when you're studying, study chapters 5 and 6. When you're studying the 1906 Act of Algeciras, study chapters 5 and 6. That's where he's talking about jurisdiction and fraud. My favorite word. Watch this. Article 101. If you get one of the most to read it, please.
The Moorish customs authorities shall directly inform the diplomatic or consular agents of any violations of this regulation, which may have been committed by those under their jurisdiction, in order that they may be prosecuted before the competent court. Similar violations by Moorish subjects shall be brought directly by the customs before the Sharifin authority. A delegate of the customs shall be charged to follow the legal proceedings in cases pending before the several jurisdictions.
So they're talking jurisdiction again. Article 101 of the 1906 Act of Algeciras. Watch this. Moors must now start to learn how to read. Article 101. The Moorish customs authority shall directly inform the diplomat or consular agents of any violations of the regulations which may have been committed by those under their jurisdiction, in order that they may be prosecuted before the competent court. Moors don't have competent courts. Why? Because Moors don't have a state. Moors claim they have consular court. No, you don't. If you don't have a state, you don't have consular court. You're not an authorized official. You have no judicial authority whatsoever because you don't have a state. Watch this. Similar violations by Moorish subjects shall be brought directly by the customs before the Sharifin authority. A delegate of the customs shall be charged to follow the legal proceedings in cases pending before the several jurisdictions. So what's happening? Delegate of the customs shall be charged. All all these people are what you call duly authorized people they're talking about, who have set up and checked all these boxes. They're not self-appointed, nothing. They're all officials that's been elected, or officials that have been elected have appointed agents to take care of the affairs of their state. So under the Act of Algeciras, if Moors don't have a state, they're subjects. Under the Act of Algeciras, if they don't have a state, they're proteges. Which means somebody else is protecting them, which means you come under their laws. Until you create your own law under your own state. Let's read Article 102.
Article 102. Every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdiction and on Moorish subject by chieftain jurisdiction.
Okay, so watch this. Technically, only Moors can deal with Moors based upon jurisdiction. But the United States, according to the ICJ, says subjects are United States citizens. Subjects are United States citizens. Why? They don't have their own state. So therefore, the country that you reside in, reside is a colonial word, not domicile. Reside is for persons. Moors domicile when they're Moorish nationals. Moorish subjects reside. Moorish proteges reside. Moorish nationals domicile. Moors keep putting in their documents that they domicile. You don't domicile. That's not to be taken as a negative. We got to correct this thing. Because if you don't have a state, you can't claim jurisdiction. And if you can't claim jurisdiction, you can't claim your domicile. You're a resident. And somebody else's corporate construct. That's the truth. Watch this. I'll give you some more reference points. Now, watch this. Moors talk about this document a lot. This is what we went over this document. What is this? This document is your citizens abroad, your 1906 citizens expatriation, protections abroad, 1906, same year, 1906. Same year, 1906. You go down to page 459 to 460, talks about Morocco. Moors talk about this all the time. Let's put it in proper sequential order. Why did the United States of America, not to be confused, United States, all of a sudden come back to the United States? Now they want to put on a record about citizenship. Because they had just left the Act of Algeciras of 1906. Proper sequential order, so they just left putting together a treaty as it relates to Moorish subjects. Now they come back to talk about these Moorish subjects who don't have a state and protections. Let's prove it. Morocco, we read this before. Okay. So I'm going to read it relatively quickly for the mothers, okay, if y'all don't mind.
Wonderful.
Sir, there are, strictly speaking, no Moroccan laws relating to citizenship of Moorish subjects in Morocco. So Moors can't be citizens, but they're classified as citizens. Why? Because you're a citizen in the United States of America. You ain't a citizen in Morocco. They're trying to say you ain't in Morocco if you ain't a Moorish national. Listen. The fundamental laws of this non-Christian country are based entirely upon the Islamic code, no part of which treats of the subject of citizenship. There are, however, numerous treaties and conventions between the various Christian countries and the Moorish Empire, by means of which citizenship in this country is defined. So they're defining Moors as being citizens, because that's how the United States talk. They say citizen. So that's their language. Moors don't have the word citizen. Moors who call themselves citizens, that's slave talk. Moors can only be nationals, or you can be a subject or a protege. But if you want your rights, you're going to be a Moorish national, a Moor, according to the treaties. Let's continue. But as I understand from the above acknowledged instructions that it is not the desire of the department to call for report upon such lines, I will therefore confine these remarks to general conditions existing, which may possibly be of some use in connection with the information desired. What information desired? They just left from signing the Act of Algeciras, 1906. Now they come back to the United States jurisdiction to talk about what was just signed. They're going to start releasing the fact that Moors don't have no protection. They're going to say it right in front of your face. Watch this. I'll continue with this. I will therefore confine these remarks to general conditions existing which may possibly be of the same use in connections with information desired. Number one, citizenship in Morocco may be said to be governed by the laws pertaining to the same and other countries, with the exception that all persons residing in Morocco who cannot prove foreign citizenship or protections are considered ipso jure as Moorish subjects. What did the ICJ say about subjects? That you are bound by the United States laws. Number 2 and 3, Moorish subjects lost their nationality only by becoming naturalized in or protected by another country, United States of America, having treaty relations with the Moorish Empire. So you lost your nationality. They put you under subject status, which means you immediately, under their laws, you became a citizen. And the only way to get out of that status, that caste system they put you in, you must have a state and pledge your allegiance back as a Moorish national. Because they got you classified as a Moorish subject. Moorish subjects have privileges. They don't have rights, they have privileges. They're stateless people. To recreate a state, you have no rights, and you will continue to get adjudicated under Title 22, United States Code 141 through 143. That's the truth. Let's continue. We'll read 2 and 3 again. More subjects lost their nationality only by becoming naturalized in or protected by another country. So if you're protected, you come under those laws. Under another country having treaty relations with the Moorish Empire. Listen, it was established by the Convention of Madrid, concluded July 3rd, 1880, as follows. So watch this. Now they're going to point out the secret that Moors have to do. Moors keep forgetting this part because we don't read. We just pronounce words. Watch this. Article 15 of the Treaty of Madrid. Moors love to put this in their documents. Total misconcepts about what it's about. Watch this. Any subject of Morocco who has been naturalized in a foreign country and shall return to Morocco shall, after having remained for a length of time equal to that which shall have been regularly necessary for him to obtain such naturalization, choose entire submission to the laws of the empire and the obligations to quit Morocco, unless it should be proved that his naturalization in a foreign country was obtained with the consent of the government of Morocco to remain as a naturalized subject. What are they saying? Moors ain't got no government that they've checked in with to say whether they want to be a Moorish national or a subject. They want to automatically just start filling out documents saying, we Moors. I checked the box, nationality. And the colonists laughing at us because they're saying, you still a Moorish subject. You never went back to your Moroccan government to put on the record your oath and allegiance to your state. They give you the answers to the test right there. You got to go back. They said choose. Moors ain't been choosing. They just been filling out proclamation documents. What did they choose? Nationality. They checked the box. That's where it starts. But guess what, Moors? There's more boxes. Watch this. Foreign naturalization heretofore acquired by subjects of Morocco, according to the rules established by the laws of each country, shall be continued to them as regards all its effects without any restrictions. Well, wait a minute. Let's read that again. Foreign naturalization heretofore acquired by subjects of Morocco, according to the rules established by the laws of each country, shall be continued to them as regards of all of the sex effects without restrictions. What are they talking about? Moors will say, oh man, as soon as I say I'm a Moor, I shouldn't have no restrictions on me. That's called having a nationality. You then have to go out and create the state. Watch this. Watch what they say. The above ruling has never yet been acted upon, and this should at any time be contemplated seriously when these Moors find out that they should be Moorish nationals instead of Moorish subjects and proteges. When they figure out they're going to be Moorish nationals, what's going to happen? Watch this. The above ruling has never yet been acted upon, and should this at any time be contemplated seriously, a large number of naturalized people, American and others, residing in Morocco will be affected thereby. Meaning that when Moors wake up and realize they need a state. Watch this. 4 and 5. Residence in the foreign parts does not affect the nationality of Moor subjects. They say you can have your nationality. And the Moorish government has no means of protecting its subjects. They say there's a Moorish government out there. That these Moors don't have no protections of them. Why?
They don't have a state.
Don't have a state in northwest of Mexico, the Maghreb, Alexa, the North Gate, Turtle Island, commonly known as the United States of America. All of our governments were usurped. The matriarchal councils were ran over by the colonists and your sellout sons. They removed our governments on this side of the world. So more have been waking up. They proclaim their nationality and they just start sending documents totally incompetent as it relates to international law. Watch this. 4 and 5. Residence in the foreign parts does not affect the nationality of Moorish subjects, and the Moorish government has no means of protecting its subjects permanently residing in other countries. Who's the other country? The United States of America. They tell you on the record, these Moors ain't got no protections. With the exception of a so-called Moorish consul in Gibraltar and a Moorish agent in Cairo, Egypt. You see what they just said? Listen, Moors. They say you got so-called protections on another continent. You don't have no protections in northwest of Mexico, which is a part of the Moroccan Empire. Moors been skipping over this. You have to create a government so that then you can go back and either quit. Moors come back and quit with a pen, or you consent to being a Moor again under your government, or you consent to want to be a naturalized citizen of the United States. You have a choice, but you got to make a choice. Let me just say this. Any Moor out there saying, I'm a citizen of the United States. Okay. But guess what? Article 15 of the Treaty of Madrid says you still have to go to the Moroccan government to get permission to remain a citizen of the United States. You just can't make a unilateral decision to do so. It's considered treasonous once you put on affairs and call yourself a Moor and a citizen. At the very least, you better have some documentation from a Moorish government that says you can remain being naturalized, or either you're working outside of international law. France has been trying to help us. You must understand. Why was this created in 1906? Because France was the common denominator putting together the Act of Algeciras, which forced the United States to come back and start talking about these Moors on the record. They forced their hand. Now watch this. So this is 1906. 1912, here comes France again. Wait a minute. France, Morocco Keep that in mind. So this is the Treaty of Fez, F-E-S, commonly known as Treaty of Fez, F-E-Z, of 1912. As soon as you go to Article 6, what does it say? Mother, please read it.
Article 6. The diplomatic and consular agents of France shall be charged with the representation and protection of Moroccan subjects and interests abroad.
Stop. Now, we've talked about this before. Wait a minute. They signed this document in the Kingdom of Morocco in Africa. So why are they talking about some Moroccan subjects abroad? Abroad means abroad in another country, in another section of a continent, etc. They talking about the Moors in northwest of Mexico who didn't have protections. The United States just said that on a document. Citizenship, expatriation, protections abroad. Who are they talking about? Moors who are in the protections of the United States here in northwest of Mexico, i.e. known as North America. So now France is coming in 6 years later. 6 years later, 1912, 1906, 1912, here comes France. Dang on the United States, y'all just don't get it. I'm going to get the Moors from underneath you. That's what France is saying. They're constantly agitating the United States of America because they know the United States of America is holding on to the trust that belongs to the Moors. France knows that they get the Moors to wake up. The game is over for the United States colonists. You must understand that. It's a strategic move on France's part to keep trying to wake up the Moors. Article 6, the diplomatic and consular agents of France shall be charged with the representation and protections of Moroccan subjects, not Moroccan nationals. Because Moroccan nationals have protections. From who? The United Nations Charter protects Moroccan nationals. Because you're poised with full powers to protect your own state. So now France has come in to help the Sultan of Morocco protect Moorish subjects and proteges. Because they don't have a state of their own to protect them. The United States said on the record, these Moors don't have protections where? Right here in what's called North America. So France is trying to extend some protections along with the Sultan. But Moors will tell you to this very day, we got protections, we got our nationality, we protect it. That ain't true. You're still a Moorish subject and a Moorish protege. That's not to be taken as a negative. We just got to fix this, mothers. Let's continue reading, mother. Section 6.
His Majesty, the Sultan, pledges himself not to conclude any act of an international nature without the previous approval of the French Republic.
So what did the Sultan do? He gave France a lot of power to go over and save the Moors. You can understand, it's not that France is our friend. France doesn't like the colonists. They want to take away the colonist trust. The global bank. So you take away the United States global Federal Reserve Bank, it's over. So France got to wake the Moors up. Then the Moors can go and represent themselves as Moorish nationals, with France being our ally. France will never have the lead. We lead. France is behind us, locked arms, working with us as ally. They've been working with us since 1631. Watch this. What am I underscoring here? France is trying to save who? Subjects. Listen. So what happens in 1913? Sequential order, 1912. France is still helping. They come over in 1913. France goes over to the United States, 1913, January. To do what? French protectorate in Morocco to save who? Moors. Relinquishment of extraterritorial jurisdiction by certain foreign powers added to the United States. They're trying to undermine the United States by waking the Moors up and giving protection. What type of Moors? Moorish subjects. What other type of Moors? Moorish proteges, because they knew the Moors didn't have a state. Watch this. The Moors aren't proteges. Yes, they are. Watch this. You go to page, I think it's 908. What does France open up with? Remember, they're talking United States. First thing they say is, if you can have the mothers read from Turning First.
Turning first to the subject of the revision of the protege list mentioned in Mr. Paredes' note of September 14th. It is proper to state
Continue.
that the protection of native Moors in Morocco by this government resets upon its treaty with Morocco of 1836 and the Madrid Convention of 1880. The relevant part of the Treaty of 1836 is found in Article 15, which reads as follows.
Stop. Moors got to pay attention. France comes over, they say, first thing I want to talk about is Article 6 of the Treaty of Fez that the Moroccan Sultan gave France full power to go and negotiate on behalf of the Moors who've been subjugated, who don't have no protections. What does he say? Turning first to the subject of the revision of the protege list. Who's the protege? The Moors. This is what the ICJ said in 1952. That subjects and proteges are still the property of the United States. Listen. Mentioned in Mr. Petit's note of September 14th in the property state that the protection of native Moors. Remember now, France that came over there in the United States. He's talking about native Moors. Because you're standing in Morocco. But what is he specifically saying? Start from the beginning. That the protection of native Moors in Morocco by the government rests upon its treaty with Morocco of 1836 and the Madrid Convention of 1880. The relevant part of the treaty is 1836 is found in Article 15. We read Article 15. What did Article 15 say? That Moor subjects, when they wake up and come back to a government, they can either choose to be a national or they can continue to remain a citizen, subject, protege. They got to choose. In the meantime, France is saying, I'll look out for those subjects because they don't have a state, because they're considered stateless people. We're in the year 2021. This was in 1913. Moors are still subjects, never put together the state. I don't say that as a negative. I say that because of the misconceptions Moors thought that we had this thing figured out. We did not. But now we're on the right track. As Judge Bey says, we got to get back on the yellow brick road. What's the yellow brick road? Studying international law, A. B, matriarchal council to put together your state. 3, we got to learn how to read as Moors. We got to stop pronouncing words. We got to take the time and break down every word that we see. Get a full comprehensive understanding. Then an overstanding, then an understanding. So when Moors say we're not proteges, that's not true. The ICJ said you're a protege. France called you a protege. That's the truth. There's only 3 classifications. That's the truth. Subject, protege, national. Pick one. Watch this. Vienna Convention of 1969, Article 1. Scope of the present convention. What's the convention? It's a treaty amongst all the nations around the world. Says what? Article 1. Scope of the present convention. Present convention applies to treaties between states, not subjects and not proteges. not self-appointed people. You gotta be a duly authorized official of your state and check the boxes. That's the truth. Watch this. We're gonna go back to Article 1 again, Treaty of 1836. What does it say? Article 1, we declare that both parties have agreed, the parties must be a state. Moors can't even get past Article 1 of the Vienna Convention of 1969. They can't get past Article 1 of the Treaty of Peace and Friendship 1836. Article 1. Why? Because we're stateless people. We can't enforce nothing until we have a state. Original jurisdiction under all treaties. You got to really understand why the Moors were subjugated around the world, because